It is day 17 of the retrial of Karen Read. We are still in the Commonwealth's case in chief. Yesterday, we heard from the coroner, which I'm sure is testimony that the jurors were waiting for. I expect we're going to get into the rest of that scientific testimony. We know the Commonwealth has 2 new medical experts, and then we have all the other scientific evidence, which I imagine is what they're going to wade through on a Friday because, well, we've got to go through DNA testing, blood testing, the manual fitting together of all the pieces of the taillight and all the rest of it. And if I'm the prosecutor, that's what I'm going to do on a Friday because the jurors are probably tired. It's been a lot this week, and that's evidence that you need like 3 sentences of that testimony, but it's so much foundation that has to be laid before you get to like what is the result that it just can feel like a bit of a slog in court. So I imagine that's what they're going to do on Friday and then start with their medical experts maybe on Monday because the jury will be more fresh then.
It's so important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk,
boy.
Don't make any facial expressions, no muttering under your breath, no audible noises.
Oh dear.
Because people need to hear what's going on and to understand everything. So out of respect for your fellow jurors, I would ask that you be very careful to make sure you do that, and out of respect to the lawyers who worked so hard to get this case before. Okay? Thank you very much.
Yikes.
That, Mr. Brennan, your first witness, please.
They have a juror that's me. They just have a juror or more that's making facial expressions and muttering under their breath. Oh my God. Somebody's like, what the fuck is this? That's me speculating. I am absolutely speculating.
Your Honor, if I may, I'd like to read a stipulation agreement between the Commonwealth and the defense.
Okay.
And the stipulation between the parties is as follows. Now comes the Commonwealth and Karen Read, the defendant, in the above captioned matter. Both parties respectfully stipulate to the following. The 2 Massachusetts State Police troopers present at the autopsy conducted by the medical examiner, Dr. Scortibello, on January 31st, 2022, were Trooper Keefe and Trooper Watson. Former Trooper Michael Proctor was not present.
All right.
Thank you.
And we still stipulate, Your Honor.
Yes, thank you.
The defense agrees.
So John's laying there on his left and his right, and I approach John from the left. That's where the street is. And he had a piece of glass, like, perched on his nose, like, just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
And the DNA profile from this item is at least...
That's the court reporter.
So sorry. I'll just restart. So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least 510 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir.
The taillight has John O'Keefe's DNA on it. Is anyone surprised? John O'Keefe's DNA and 2 unknown DNAs on the taillight. So it is at least 510 nonillion times more likely that is John O'Keefe and 2 unknowns than it is 3 unknowns. So it is John O'Keefe plus 2 unknown DNA.
And what conclusions were you able to draw from the testing that you did on the hair?
Yeah, so there was no human DNA detected and STR analysis was not performed.
Now, what does that mean, sir?
Yeah, so
can you just tell us if it's a dog here? That's really all we want to know at this point.
So there might be DNA on there, but it was below what our instrumentation could detect.
Now, with respect to any of those items, there were some items that pieces within the same bag that had the same date on that bag did not fit together mechanically, correct?
Yes.
However, there were items from one bag collected on one date that did fit mechanically with items from another bag collected on another date. Is that correct?
Yes.
Do you have a report on that? I don't know if I have a report on that, and that would be why.
Do you have a record of that in your report in terms of who it was that brought the material to your lab?
I could look at the evidence submission form to see who.
With the court's permission?
Yes.
Because it would go through the different departments first. So
Okay.
Brennan asked to approach.
All right, go ahead, Mr. Manning.
Having reviewed your reports,
I did. I
can
started it.
you testify to the jury about who it was that brought this evidence into the lab?
So you can tell us.
Okay. So submission 7, all the items that are 7- was submitted by Trooper Michael Proctor.
Shocking!
What date was the clothing brought to your lab?
Clothing was in March.
March 14th, 2022.
So that means that your chain of custody at the lab began on March 14th of 2022, correct?
Yes.
And would you agree with me
about
that was
the
about
taillight?
6 weeks after the date of the incident, January 29th of 2022?
Yes.
And of course, you can't speak to the chain of custody from January 29th to March 14th of
I don't know what
2022,
happened.
correct?
Nope.
Correct.
And you have no information and do not know why Michael Proctor waited 6 weeks to bring this clothing to your lab, do you?
Sustained. We've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination, certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well. So regarding Dr. Welcher, as my understanding, the request yesterday was for, and it's been a request, I think, a few days. We've addressed it at sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief next week or so, Mr. Brennan.
Hopefully next week, if not
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right. So I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objections were noted. I'll see everybody on Monday.
At the end of week 3, the defense has kept the pressure on this investigation. The prosecution has finally called the coroner, which I think has also kept the pressure on the investigation. And at the beginning of the day, we learned that the troopers at the autopsy were Trooper Connor Keefe and Trooper Watson. You're going to leave a comment saying, Emily, WTF is Watson? I don't know. I think this is the first time we've heard Watson's name. And my question is Watson part of the CPAC unit? Because Yannetti very clearly asked Trooper Keefe in his cross-examination, was anyone else from your unit at the autopsy? And to that, he said no. So was Trooper Watson part of the unit, CPAC at the Norfolk DA's office, or was Watson from a different unit? Which is possible. But now I don't think we're ever going to get an answer. But did I think that picture looked like Proctor? Yeah, it sure did. Is this why I say we have to wait because the lawyers will give us the information? Yes. Did I break my own rule? 100%. Why? Because it's so freaking weird. Apparently, Watson was the other trooper at the autopsy. And how do we know that that's a verifiable fact? Because it was stipulated to by the parties. The defense and the prosecution stipulation means it is a fact that is not in dispute. And yes, I know the photo was titled Keefe or Connor and Proctor at what seemed to be autopsy. The defense put those labels on their photos in their system. I'm actually pretty surprised the prosecution hasn't objected to those, because the defense has labeled their photos all kinds of things that the jury has seen, and the prosecution could object and the court could force them to redact it, because are the file label names argumentative? Yes. Has the prosecution objected to it? No. Could they? Yes. And the court could force them to redact it, and they haven't. So do I rely on the file names placed there by the defense? No, they're argumentative. Of course the defense is going to label them the thing they want you to think. That's what they do. And the Commonwealth hasn't caught it. I don't love it. It should be photo 1127 or whatever, but it's not. I don't put facts onto the file names because I know that they are naming their files themselves. To wrap up the rest of the day, we ended the day with the crime lab puzzler, Ash Valair, who pieced together the taillight. This testimony came in, I think, much quicker and much smoother than it did in the first trial. It is still a lot of numbers and trying to correlate bags of evidence, what's inside those bags of evidence, and then how they were puzzled together or manually fit together to construct or reconstruct a taillight. And the expert opinion of that witness is that the items identified in all of that 7 series evidence bags did at one point come from the same item. So those pieces of taillights did come from the same item. What I really would have liked to have seen, and I'm still very curious about, is what items weren't fit together. Because when the witness was testifying about that, they talked about the numbers in that bag that fit. And it wasn't always the totality of that evidence bag. So what I'm really curious to see is what pieces fit together and what, if anything, didn't fit back together. I know there were glass pieces that were in those evidence bags in a number of the 7 series evidence bags, and there were black pieces of plastic. I'm interested to see what was reconstructed and then what are the leftovers, or are there any leftovers? That I was curious about. It didn't come up in cross. It didn't come up in direct. I don't think we'll get that question answered. But then as Yannetti went through his cross-examination, Yannetti and the others on the defense team have done a really thorough job of asking the scientific witnesses, who I think the jury will very much like, to ask the scientific witnesses about whether they had control over the items before they got to the lab. Now, of course they didn't, but it highlights for the jury that, well, garbage in, garbage out, right? You don't know what happened to the clothing, the taillight, or anything else before it got to you. All you can evaluate is the evidence as it is when you received it. And your protocols are followed and your chain of custody is followed, but you have no idea what happened before that. And highlighting for the jury who had access to all of these things. Well, shocker, it was Trooper Proctor. And the defense has consistently in cross-examination brought up Trooper Proctor's name to the point that I wonder if when the defense asks a witness, can you tell me which trooper brought this to the crime lab? That the jury in their head is going, oh, I bet it was Trooper Proctor. I can't imagine that they're not at this point filling in the blanks for themselves. And that is a problem that the Commonwealth is going to have to address, because the defense is moving fully ahead with their Bowden defense that this investigation did not follow investigative leads and was not well done. And I think they've highlighted that. It makes the case cleaner for the jury than, I think, running down all of the avenues of what did Higgins do? What did Albert do? What did this person do? What did that person do? I think it's much cleaner to leave those questions for the defense. The defense asked the DNA expert today. There were all these unknown samples. Were they tested for Brian Albert or against Brian Albert? No. Were they tested for Brian Higgins against Brian Higgins? No. The DNA analyst responded over and over and over again. Those other samples could be anyone. Don't know. Could be anyone. And it leaves those questions unanswered, which is a problem for the prosecution and goes to the Bowden defense for the defense. So they didn't follow this investigative lead. They didn't follow that investigative lead. They didn't test the DNA on the taillight. They didn't test those unknowns against these other individuals. So was it really a thorough investigation? It's a fair question. And I think the difference that we're seeing between this trial and the first trial is, one, the questioning on both sides is just cleaner. And I think that's because the direct examinations are so much cleaner. It is easy to see what the witness testifies to affirmatively and then what they testify to in cross-examination. So it just is easier to follow. But the defense also isn't running after all of the third-party defense witnesses as much, so there aren't as many side quests. My concern when there are too many side quests is it shifts the jury's focus away from what did this investigation to and shifts their focus to, oh, well, what did Jeb McCabe do? Oh, well, what did Brian Albert do? Oh, well, what did this person do? And then they're looking towards the defense to prove to them and to close those loops. It's not the defense's job to close loops. It's their job to make sure that the prosecution doesn't close the loops. That's their job. It's the prosecution's job to close the loops. And I think in the way the defense approached it in the first trial, it left some loops open for the jury. And pointing everything back to the investigation continues to point back to what the Commonwealth has proved and continues to push that back onto the Commonwealth. What did they prove to you? And the defense's theory of the case is very clear from their opening. No collision. And they have used their cross-examination strategically to push back at no collision. How they will address whether or not there is a time shift here will be very interesting, and we'll have to see it as that evidence comes in with the witnesses because we know that it's coming in. But I don't doubt that Alessi will fulsomely cross-examine that witness that this has shifted, because it seems that it has shifted, but the court doesn't see that as new. The court has issued her ruling with regard to two issues. One, the experts regarding the time shift, time warp, wibbly wobbly, and two, regarding ARCA and the aperture experts for the prosecution. Let's start with the second part because it's easier. With the aperture ARCA issue, and those are the Commonwealth's aperture experts and the defense's ARCA experts, the court did not block ARCA from testifying when the Commonwealth asked, and asked ARCA to get their new testing and new reports and new opinions in by May 7th, and ARCA has done that. The Commonwealth has complained that they did not have enough time then to have their expert review the new findings. So what the court has allowed is that the aperture experts would testify in the case in chief for the Commonwealth regarding ARCA's previous expert opinions and what they had said in their previous reports, which were turned over briefly in advance of the first trial. The Commonwealth said that ARCA has new opinions and numerous new opinions in this trial. That doesn't surprise me. ARCA has been hired by the defense now, not just by the feds, and has asked ARCA to act as responsive witnesses to the Commonwealth's new expert. So ARCA has turned over all of their information and the Commonwealth's experts going through it. The court is going to allow the Commonwealth to use their expert in their case in chief and then bring their expert back in rebuttal only as to ARCA's new information that was turned over late to the Commonwealth. And whether or not, and I'm sure there are lots of opinions about whether the defense has reason to turn it over late or not, it is still late as just a matter of course, and the expert needs time to review it. So the court decided to allow that to be split. Could the court have delayed the trial? I suppose. Did that happen? No, we're in trial and here's where it is. So the Commonwealth, if they choose to, will be allowed to bring their experts back in rebuttal only to go over the new information from ARCA, not the previous information from ARCA. So that is the ARCA issue. That is how the court is addressing it. The court did not block ARCA's new opinions. The court did not limit ARCA's new opinions. The court did make the defense jump through quite a bit of hoops on that, including the voir dire and the rest of it, but the court is letting that all in and has given the Commonwealth more time to address it, which means that the defense is going to be very busy because the Commonwealth's expert is still going to be working regarding the new opinions from ARCA. Back to the experts over the clocks and the time shift. The prosecution is arguing that all of the underlying data and all of the information had been turned over to the defense. And even though there is a new report from their expert from May 8th, that new report is not new information. That is what the Commonwealth argued this afternoon. The defense argued that it absolutely is new information and that it changes the timeline and that the Commonwealth is shifting the timeline to match Whiffin's testimony and asked for a voir dire and then gave the reports to the court to review. The court reviewed the reports today and said that the defense did not suffer unfair surprise or undue prejudice and that it was not late disclosure. What I can gather from what the court is saying is that she does not agree that this is new information, even though it is a new report, and told the defense that that was all grounds for cross-examination. She also told the defense that she was going to give them pretty wide latitude on what is going to be a battle of the experts issue. You can cross-examine on why there is this new report. You can cross-examine on whether or not they broke the sequestration order. You can cross-examine on all of this. And the court has indicated that at the end of direct examination of the Commonwealth's expert, if the defense feels they need more time, that she will entertain the defense asking for more time then, which is a really clunky remedy, in my opinion. But she also told the defense, if after the Commonwealth's expert testifies, the defense wants to recall witnesses that they had previously called, that the court would allow them to do that. Earlier in the trial, I have been asked quite a lot, can the defense call this witness back or call this witness back? And I have said repeatedly that the only reason you're recalling an expert is if you need to cross-examine them or examine them on something you could not have examined them on when they were on the stand. And the court is indicating with that ruling and finding that this is something that they could not have been examined on when they were on the stand. So she will entertain allowing the defense to recall those witnesses, which is not dissimilar to what she did in the first trial when there were issues that were discovered later and the defense said, this witness has already testified. You might remember if you watched the first trial at one point, the court said, do you need to call this witness back? And Jackson said in court, I've done the damage I needed to do to this witness, but was nonetheless frustrated. In this case, I've seen a lot of questions, particularly around this area. Why isn't this a mistrial? The defense did not ask for a mistrial. The defense asked for more time, which they're also going to get because the court is taking a little more than a 4-day weekend for Memorial Day, is taking a half day Thursday, full day off on Friday, and then a full court holiday on Monday. So the defense will get the time that they asked for. They said they needed about 4 days and they're going to get that. But the defense did not ask for a mistrial in this case. Why? Because then they start over. It just resets the case back to starting this trial again, and they don't want to do that. I think the defense has made some really good headway in this trial that they wouldn't want to lose, because who knew there would be this many surprises in this retrial? And there have been, I think, some significant moments for the defense. Are they going to have to work with this? Yes, they are. Is that what the court ruled? Yes, they did. But without seeing the reports, I'm very curious as to where the interpretation of those reports lies, because, well, we don't have them. And without having those reports, it's difficult to ascertain how the court is seeing it. So what we can go off of is what the defense said, what the Commonwealth said, and what the court said. And I know that not everyone is going to like what the court said. However, we don't know what's in the reports. We know what's represented to be in the reports. And both the attorneys can get a bit hyperbolic on the representation of things. I'm really curious to see what the cross-examination is and to see how that unfolds. I was hoping for a voir dire just so we would have more understanding, because we don't know. We don't have the reports. I'm very curious, if there's nothing new, why is there a new report? However, if this is a massive shifting issue, then why did it not come up closer in time to when this report was turned over? So those are the questions I am left with. And I wonder if cross-examination of that witness is going to last at least a day, because, oh boy, there is going to be a lot to cross-examine that witness on. It has been a very interesting day for day 17 at the end of week 3 of evidence in the retrial of Karen Read. The Commonwealth said they thought they had about 23 days at most of their case in chief. So we're getting to the end of the case in chief for the Commonwealth. Who are they going to call? And I was very surprised that we did not hear today from the neuropathologist, Dr. Stonebridge. Maybe we will get into those medical experts next week. I think it was a good use of Friday for the Commonwealth to stick the scientific evidence on Friday, just like plop it on Friday. It was a full day of Lally doing the questioning, whole different lawyer than last trial, Lally is. And it's information that's foundational and important, but it's also information that the jury is going to remember part of and will come up with other witnesses. So laying that foundation all day on a Friday makes a lot of sense to me, because the jury's probably fatigued. And we didn't even get to talk about the judge much, telling the jurors to mind the subtitles on their faces, my words, not hers, at the beginning of the day. What a busy week this has been. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.